A federal court has delivered a landmark ruling striking down the Trump regime's policy of detaining and deporting foreign students and scholars for expressing pro-Palestinian views, finding it an unconstitutional attempt to silence dissent. The 161-page opinion issued by U.S. District Judge William G. Young in Massachusetts represents one of the most forceful judicial repudiations of government overreach into free speech in decades. The lawsuit was filed in March by the American Association of University Professors, several of its chapters at Harvard, Rutgers, and New York University, and the Middle East Studies Association. Their case centered on the arrests and attempted deportations of non-citizen academics and students who had spoken in support of Palestinian rights. Among those detained were Mahmoud Khalil, Mohsen Madawi, Romeza Ozturk, and Badar Khan Suri, individuals who had not been accused of crimes, but whose public political statements had drawn scrutiny. Their arrests created a climate of fear on college campuses, where many foreign scholars began self-censoring, worried that participation in political debate could trigger deportation. At issue were two executive orders signed by Donald Trump in early 2017. These measures authorized immigration authorities to remove non-citizens who espouse hateful ideology and pledged to intensify efforts to combat anti-Semitism. The plaintiffs argued these orders were used as a pretext for a systematic campaign to target pro-Palestinian voices under the guise of national security. In his opinion, Judge Young declared the practice unconstitutional, stressing that the First Amendment's protections extend fully to non-citizens lawfully present in the United States. This case squarely presents the issue whether non-citizens lawfully present here actually have the same free speech rights as the rest of us, he wrote. The court answers this constitutional question unequivocally. Yes, they do. Young emphasized that the First Amendment's text contains no exceptions. No law means no law, he continued, underscoring that while free expression has limits, such as incitement or true threats, those limits are identical for citizens and non-citizens alike. The judge found that the regime had gone beyond legitimate immigration enforcement and instead used the Immigration and Nationality Act in unprecedented ways to punish political viewpoints. According to the ruling, officials sought to make examples of a few outspoken individuals in order to chill broader dissent, especially pro-Palestinian activism on U.S. campuses. Testimony at the July trial revealed that the State Department and immigration agencies had drawn on dossiers produced by Canary Mission, a secretive pro-Israel group known for doxing thousands of students and academics critical of Israeli policy. Several officials admitted under oath that they had been instructed to compile allegations against targeted individuals using such sources. The government, meanwhile, attempted to block disclosure of internal records that could have further illuminated its decision-making process. Attorneys argue that visa revocations and deportation orders were made on a case-by-case basis, and that the plaintiffs were imagining a broader policy. Judge Young rejected that explanation as implausible given the consistent pattern of actions against pro-Palestinian advocates. He concluded that the administration's intent was not neutral immigration enforcement, but in his words, something more invidious, to create fear and discourage others from exercising free speech. Witnesses described the profound chilling effect created by the arrests. Scholars testified they'd avoided publishing articles, speaking at rallies, or even traveling abroad out of fear they would be barred from re-entry. Bernhard Nickel, a German-born Harvard philosophy professor, recounted how he abandoned both professional opportunities and personal obligations, including a chance to visit his dying brother overseas because of the risks highlighted by Ozturk's detention. Judge Young sharply criticized a government lawyer who, in cross-examining Nickel, suggested that his fears were merely the dizziness of freedom. Young reserved some of his strongest criticism for immigration and customs enforcement, blasting the agency for what he described as intimidation tactics. He took particular issue with ICE agents wearing masks during arrests, writing that the government's defense of the practice was disingenuous, squalid, and dishonorable. ICE goes masked for a single reason: to terrorize Americans into quiescence, Young wrote. In all our history, we have never tolerated an armed, masked secret police. He contrasted ICE's approach with the military, noting that US soldiers do not hide their faces, even on the battlefield, because honor still matters. Young further criticized ICE for portraying itself as a criminal law enforcement body while actually operating under a civil mandate. Its warrants, he pointed out, are not reviewed by independent judges, but signed internally by supervisors, and its immigration courts lack the independence of Article 3 courts. The opinion also included a broader critique of presidential power. Young concluded that by defending and advancing this deportation policy, Donald Trump had violated his oath to preserve, protect, and defend the Constitution. However, he acknowledged that a 2024 Supreme Court decision granting presidents sweeping immunity left Trump effectively shielded from personal accountability. That the president is, for all practical purposes, immune from consequences for this conduct does not relieve this court of its duty to find the facts, Young wrote. He warned that the regime's actions threatened the very foundation of American democracy. I fear President Trump believes the American people are so divided that today they will not stand up, fight for, and defend our most precious constitutional values so long as they are lulled into thinking their own personal interests are not affected, he wrote. Is he correct? Civil liberties advocates hailed the decision as a landmark. Todd Wolfson of the AAUP called the deportation campaign a betrayal of American values and praised the court for exposing its true purpose: to silence dissent. The Justice Department declined to comment. Observers expect the ruling to be appealed, possibly reaching the Supreme Court, where Donald Trump has favorable judges. The opinion stood out not only for its conclusions but also for its deeply personal tone. It opened with Young's reply to an anonymous postcard he had received stating, "Trump has pardons and tanks. What do you have?" His response, "Alone I have nothing but my sense of duty. Together, we the people have our magnificent Constitution." Young closed the decision by quoting Ronald Reagan's famous reminder that freedom is fragile and must be defended by every generation. And in a final note to the anonymous postcard sender, Young signed off, "I hope you found this helpful. Thanks for writing. It shows you care. You should." And with this decision, the court made clear that the First Amendment, tested and threatened, had ultimately won out. I'm Anthony Davis. You can find me on the 5-Minute News YouTube channel and podcast, on Wednesdays co-hosting Uncovered, and on Sunday on The Weekend Show with MeidasTouch.
Love this video? Support independent media and unlock exclusive content, ad-free videos, and custom emojis by becoming a paid member of our YouTube channel today. You can also gift memberships to others. Let's keep growing together.